Can I just say something about Andrea?
Guys, we're going to be doing a little bit of a deep dive into the civil lawsuit that was filed by the surviving family members of Xana Kernodle, Ethan Chapin, Madison Mogan, and Kaylee Consalvis against Washington State University. This complaint has gotten a fair amount of attention, I think largely because of the factual allegations that the complaint contains. The kind of 10,000-foot view of what's going on with this lawsuit is that the families are alleging that by failing to properly respond to concerns about Bryan Kohberger's conduct towards primarily female students, professors, other teaching assistants, and so forth, that he interacted with in the course of his PhD work at the Washington State University, that because of their failure to properly intervene and address the behavior, that his behavior escalated, and that ultimately caused the murders of the Idaho 4 in November of 2022. The reason I'm not going to focus at length on the factual allegations, there's really a couple of them. I mean, one, there's plenty of commentary out there already about it. The complaint is there; people can read it. Important, as always, to bear in mind that allegations are just that. The complaint itself indicates that a lot of the basis comes from, some of it comes from court documents and police reports and things like that that have been released publicly since Bryan Kohberger was convicted. But they also refer to just public information in the quote-unquote public record. And of course, if you followed Kohberger, you know that the public record was kind of an ongoing issue in terms of reliability and accuracy and things like that. The parties, in fact, had to have an entire hearing about some of the reports that were being disseminated publicly, potentially contaminating the jury pool in Latah County, requiring, for example, Bill Thompson, the prosecuting attorney, to emphasize quite vehemently that allegations that Bryan Kohberger had stalked the Idaho 4 victims was false. So nevertheless, certain allegations and rumors and things like that persist. Another example being that Bryan Kohberger followed the one or more of the victims on social media. This is an allegation that is longstanding, has been repeatedly debunked, including as recently as right after Bryan Kohberger pleaded guilty. Again, the prosecuting attorney emphasizing publicly that law enforcement was never able to identify any type of connection between Bryan Kohberger and the victims, was never able to place them in the home, was never able to place them in the same place at the same time, and wasn't able to identify any communications between them. So, you got to take the allegations as they are. It's also important to bear in mind the context of the allegations being made. This is a civil suit, and so the purpose is to paint the most egregious picture you possibly can. And so it's understood that there is going to be some cherry picking of facts and information and so forth, because you're not here to allege reasons why perhaps the school is not liable for Bryan Kohberger. You just selectively present the ones that you think are most beneficial to your position. So the last reason why I'm really not going to focus on the facts here, like much at all, except as we need to focus on what I intend to do, which is a little bit more of a legal deep dive into what is going on with this complaint, is because at the initial stages of the case, the truth or falsity of the allegations doesn't matter. When you're looking at the legal sufficiency of a complaint and basically the likelihood that the complaint is going to move forward through the process into discovery and potentially to trial, when you're doing that type of legal analysis, you start from the assumption that all these facts are true. Let's assume everything that's alleged in here can be proven. And if that's the case, is it still enough for them to be able to file a cause of action? So the reason I got interested in this, of course, is because I'm kind of curious about the theory of how is WSU responsible for Bryan Kohberger off campus murdering non-WSU students, not part of a school activity, anything like that. It seems quite remote to me. So I wanted to do a little bit of digging deeper into, is my gut right on this, or is this something that the law is going to contemplate a pathway for it? So that's going to be my focus in this video, is to talk about the legal claims that are being presented and what the standards are going to be, what the facts kind of have to establish in order for a claim to move forward on these grounds. So first, just to quickly take a look at those claims themselves here in the complaint. The main ones that are like critical are count 1, the Title IX claim, which is of course a federal law claim. This was the basis for moving the case into federal court. And then the second and third claims are more or less crossover. Let me get to it. They go into a lot of detail for reasons that we will discuss. So I'm not going to go through this at length right now. Okay, finally, finally down here at count 2, negligence. This is a state law claim under Washington state law. Count 3 is essentially the same thing. It's just count 3 is gross negligence. So basically, arguing negligence, but a little bit worse. All of the remaining claims are survivor claims. This is basically a wrongful death type of attribution of standing, kind of more than anything else. It's not an independent standalone claim. It depends on one of these bases for liability being established. And then if it is, kind of provides the mechanism for the estates of the decedents to be proper parties to make the claim. So that's the context that we're in. It's the estates of the Idaho 4 that are acting as the plaintiffs in this case. So we're going to start with this negligence claim, the state law claim, mainly because I think it's a little bit easier to kind of deal with from a legal standpoint, but it also gives us a little bit of the framework that we're going to need to kind of dig into the Title IX claim and where the potential issues are with that. So they're, of course, incorporating each and every allegation. The overall broad allegations here factually are simply that Bryan Kohberger behaved in ways towards his fellow students and colleagues and so forth, primarily females, but not exclusively, that they found uncomfortable and potentially threatening. This ultimately culminated in 13 formal complaints being filed with the students, forget the exact name, the civil rights, basically the Title IX office at WSU. The office never contacted Kohberger, and so not really clear whether any investigation was conducted as a result of any of that. But the issue kind of circles around how did WSU respond? Like, what did they know? When did they know it? And was their response adequate? And so it's a little bit complicated from my perspective by the fact that a lot of what is alleged as problematic behavior is kind of ambiguous. It's one of those situations where it's possible to interpret it in a light that is favorable to Mr. Kohberger. We know that he has an autism diagnosis. We know that that is commonly associated with social deficits and not picking up on clues and things like that. And so it's possible to interpret a lot of the allegations in that light. that this is simply somebody who doesn't know how to talk to girls, doesn't know how to pick up on somebody being done with the conversation and ready to go, and potentially those tendencies being a little bit exacerbated by what seems to be a lack of willingness on the part of some of the people involved. And I'm focusing primarily on his supervising instructor at this point, who's like an authority figure, but seemed to be kind of unwilling or unable to assert boundaries with Bryan, and just, for example, say, like, this conversation is over. It's time for me to go home. We can pick it up another time, or something like that. The professor kind of reported that he got uncomfortable because Bryan would start conversations with him like at the end of the day when he was ready to go, and not pick up on the cues that he wanted to leave. So possible, favorable interpretations are available. These are not situations where he overtly threatened anybody, explicitly said he's going to do something, explicitly did anything sexual. I think the closest that there is to that was an allegation that he asked out a fellow student. The fellow student said no, and Bryan then followed her to her car. So possible to interpret it in a beneficial light, but also possible to interpret it in a negative light. That's the problem with ambiguity, is a lot of it depends on perspective. And so there are certain allegations where it's a little bit more reasonable, I think, to infer that the people involved would have found the situation physically threatening. There was, for example, accounts of Bryan Kohberger blocking doors so that girls weren't able to exit, being kind of like physically looming during conversations, accusations of following women, which yeah, that can be quite threatening. And so the situation is, again, for purposes of this motion, they would assume, like a motion to dismiss, they would assume that all of those facts are true, and we would assume the negative interpretation against Bryan. We would just assume the jury is going to see this entire situation exactly the way that the plaintiffs are presenting it, and so that's going to be sort of the factual context that we need to take into this legal analysis, is understanding that ultimately, if it gets to trial, a jury is going to have to make these decisions. But for purposes of deciding if it even gets there, we assume the worst. Like, we assume the worst possible interpretation, but we don't take it beyond the facts that are alleged. Like, we don't assume that there's like worse conduct that hasn't been pleaded or something like that. We're stuck with the facts as they're presented, but we interpret them in the light that is most favorable to the plaintiff. That's going to be probably as much as I get into about the facts here, except as they kind of become relevant through the pleadings. So incorporate each and every reference as above. So allegation: WSU had a duty to exercise ordinary care and refrain from negligent acts and omissions, duties that arose out of a special relationship between Kohberger and WSU under Restatement Second of Torts 315A. So this is going to be important. They're arguing that it's based on the nature of the relationship between WSU and Bryan Kohberger, that WSU had a duty towards non-students in their off-campus house. WSU failed to exercise ordinary care in its special relationship with Kohberger and was negligent. As Kohberger's employer, WSU also had a duty to exercise reasonable care in hiring, supervising, and retaining Kohberger as an employee. WSU was negligent in hiring, supervising, and retaining Kohberger as an employee. So we're seeing first a negligent employment. You didn't properly vet and manage your employee when you became aware of his problematic activity. WSU also had a duty to exercise reasonable care so as to control Kohberger while acting outside the scope of his employment, so as to prevent him from intentionally harming others under Restatement Second of Torts, Section 317. alternative theory of liability under tort. WSU was negligent when it failed to control Kohberger so as to prevent him from intentionally harming others. WSU also owed a duty of care under Restatement Second of Torts, Section 302B, where its own affirmative acts create or expose someone to a recognizable high degree of risk of harm through such misconduct, which a reasonable person would take into account. Third theory of liability, that WSU participated in bringing about the harm on King Road. An act or omission may be negligent if the actor realizes or should realize that it involves an unreasonable risk of harm to another through the conduct of the other or a third person, which is intended to cause harm even though such conduct is criminal. WSU was negligent by its own affirmative acts that created and exposed the decedents to the recognizable degree of risk of harm posed by Kohberger. WSU's adoption of, these are basically threat analysis and assessment protocols, heightens these duties as these frameworks mandate proactive assessment and intervention for behaviors like threats or stalking, which align with known red flags in violence prevention and caution against certain responses that can heighten the risk of violence. WSU had a duty to use reasonable care to control Kohberger and protect members of the Pullman-Moscow community, including decedents, from foreseeable harm and the imminent danger that Kohberger posed. As described in detail above, there was a definite, established, and continuing relationship between WSU and Kohberger. The relationship between WSU and Kohberger was unlike WSU's relationship with a typical individual student. Here's why. WSU offered Kohberger employment as a teaching assistant for a definite period of time, the 2022 fall semester and 2023 spring semester, with defined and established expectations of performance and behavior pursuant to a written employment agreement. WSU affirmatively brought Kohberger to the Pullman-Moscow community from the East Coast, and its offer of employment included a requirement that he reside in Washington. As a result of this agreement, WSU expected to receive teaching assistant services that benefited WSU undergraduate students and faculty. For instance, WSU policy provided that Kohberger's primary duty was teaching or serving as a teaching assistant, and he was required to be at work each normal workday, including periods when the university classes are not in session. In return for his teaching assistant services provided to WSU, Kohberger received a salary, health benefits, an on-campus office, housing, and tuition. Efforts that Kohberger engaged in to identify the decedents, stalk and plan his attack that occurred in his on-campus office or on-campus housing, or using WSU's ResNet internet network, are activities occurring on WSU premises. As part of their relationship, WSU required Kohberger to follow the Graduate School Policies and Procedures Manual, the WSU Department of Criminal Justice and Criminology Graduate Handbook, the Apartment Agreement, the Network Service Agreement, and the WSU Standards of Conduct, all of which applied to both on and off campus conduct. WSU required that Kohberger maintain high standards of professional and ethical conduct and to show respect for undergraduate students. WSU agreed to provide adequate supervision and training and specifically assigned WSU faculty to serve in that capacity with Kohberger. Kohberger engaged with his WSU supervisors on a nearly daily basis. WSU had the ability to control Kohberger and, in fact, did exercise control over Kohberger. WSU also knew of the necessity and opportunity to exercise control over Kohberger. WSU had the ability to use its multidisciplinary threat assessment tool to conduct a threat assessment using its WAV R21 protocol to identify Kohberger's propensity to commit violence and to implement measures to mitigate that risk, but failed to do so. WSU had the ability to use its Center for Community Standards, to investigate and enforce the numerous standards of conduct that Kohberger repeatedly violated but failed to do so. WSU had the ability to discipline Kohberger or terminate his employment and defund him at any time if he engaged in misconduct, had deficient job performance, or violated university policies, but failed to do so until after the murders. WSU was the entity solely responsible for ensuring that Kohberger complied with the terms of the various WSU agreements, policies, and procedures that Kohberger was bound to abide by. Interventions like monitoring or removal likely would have prevented the murders by breaking Kohberger's access and momentum. Had WSU followed its policies and procedures, including but not limited to escalating complaints to a full assessment and threat CAT review, it likely would have prevented escalation by triggering interventions including counseling, mental health referral, suspension, expulsion, or law enforcement referral, thereby averting the mass murder by removing Kohberger from his position and the Pullman-Moscow community long before he committed the murders. Indeed, after the murders, WSU exercised the ultimate control over Kohberger and terminated his employment, defunded him, and served him with a trespass admonition prohibiting his presence at WSU. WSU knew or should have known that Kohberger habitually engaged in misconduct in a manner dangerous to others. WSU affirmatively mismanaged the numerous complaints that it received about Kohberger's inappropriate behavior, including but not limited to attempts to contain these complaints within the criminal justice and criminology program, avoiding escalating complaints to proper authorities, engaging in ineffective and informal discussions with Kohberger, and affirmatively keeping him employed at WSU. Through its close relationship with Kohberger, WSU had substantial insight into his dangerous propensities and was aware of the identities of various victims, primarily young female students. As undergraduate students living in the Pullman-Moscow community, decedents were foreseeable targets and victims of Kohberger. It was reasonably foreseeable to WSU that Kohberger would engage in future and escalating misconduct and dangerous and predatory behavior, including violence, if action was not taken to mitigate that imminent threat. Had WSU's TAT conducted a proper WAV 21 assessment and followed the recommendations and warnings of that threat assessment and intervention protocols, it would have known that Kohberger was a ticking time bomb ready to explode and should not have embarrassed him in front of his entire cohort when it mandated remedial sexual harassment and discrimination training for all students, but solely because of Kohberger's behavior. WSU was aware of Kohberger's repeated instances of inappropriate, predatory, and menacing behavior occurring within days of him first appearing on the WSU campus, and WSU breached its duty of care and was negligent in one or more of the following respects. A, hiring Kohberger and bringing him to the Pullman-Moscow community without conducting an adequate background check and other pre-employment vetting. B, failing to adequately train and supervise Kohberger. C, failing to follow WSU policies and procedures. D, failing to timely report Kohberger's inappropriate and menacing behavior to WSU's threat assessment team, and failing to perform an adequate threat assessment of Kohberger and failing to implement necessary, proper, and urgent measures to mitigate the imminent threat posed by Kohberger. E, failing to report Kohberger's inappropriate and predatory behavior to appropriate WSU administrators and law enforcement. F, permitting the Criminal Justice and Criminology Department to address Kohberger's behavior through informal, piecemeal, indecisive, and wholly inadequate faculty discussions and ad hoc responses, instead of urgently involving appropriate WSU administrators and law enforcement. G, failing to timely report Kohberger's inappropriate and menacing behavior to WSU's Center for Community Standards, and failing to promptly and thoroughly investigate such reports and take urgent action against Kohberger. H, failing to timely report Kohberger's inappropriate and menacing behavior to WSU's Compliance and Civil Rights, Title IX office, and failing to promptly and thoroughly investigate such reports and take urgent action against Kohberger. Failing to monitor Kohberger's inappropriate use of WSU ResNet Internet Network and take appropriate and urgent remedial action. J, failing to enforce WSU policies and the rental agreement by failing to inspect Kohberger's residence following reports of his harassing, stalking, and menacing behavior, and failing to enforce the rental agreement's prohibition of weapons on campus property and in on-campus housing, including the K-bar knife that Kohberger used to assault and murder the decedents. K, mismanaging the numerous complaints and reports of Kohberger's inappropriate behavior. L, failing to intervene in Kohberger's discriminatory, harassing, and stalking behavior. M, failing to discipline Kohberger. N, retaining Kohberger as an employee of WSU following numerous reports of his dangerous and alarming behaviors, beginning with the earliest days of his employment. O, failing to terminate Kohberger from employment with WSU and failing to defund and remove him from campus. P, failing to warn the Pullman-Moscow community of the danger and threat posed by Kohberger. Q, placing the financial condition and reputation of WSU above the safety and security of the Pullman-Moscow community in general and the decedents in particular, and R, in other respects that may be revealed during discovery. It's quite a long list there, somewhat repetitive in many cases. It reminded me, some lawyers sometimes love their synonyms. I do hereby, bequeath, devise, gift. Just like the sense that like you need to include every possible way of saying something so that you don't maybe overlook the important one. Usually it doesn't matter, but sometimes it does. So that's why they include, for example, both retaining him and not firing him, even though those are exactly the same thing. If WSU had exercised reasonable care, Kohberger would have been neutralized as a threat long before he committed the murders, and WSU's negligence caused, in fact, and substantially contributed to the assault and murder of decedents, and as a result of WSU's negligence, plaintiffs were damaged. So it's quite a long claim of liability, a basis for why they are saying WSU is negligent. But at the kind of 10,000 foot level, basically what they're saying is that WSU was on notice that Bryan Kohberger was a threat. And so based on the notice that they have had from the reports that they received, they had a duty to do something about it. And by failing to respond the way that the plaintiffs are suggesting would have been the appropriate response, it allowed Bryan Kohberger to kind of set in motion the chain of events, or I guess maybe failed to break the chain of events that ultimately led to Bryan Kohberger committing the murders at 1122 King Road. So we're going to now turn to what, in my view, is likely to be a nearly insurmountable problem for the plaintiffs in being able to pursue this claim. And this is this case right here that came out of the Supreme Court of Washington, January of last year. So it's just over, or 2 years ago, just over 2 years old now. No question that the plaintiff's attorneys knew about this case, wrote their complaint with this case in mind, and made certain decisions about how they are presenting certain facts in order to address this case. And so here's what it's about. It's also a case against Washington State University, so they themselves are pretty familiar with this decision. So this was sent to the Washington Supreme Court by the Ninth Circuit. What happens is that sometimes in federal court, if a case is being litigated that involves questions of state law that are not real clear, they haven't had decisions directly on point, it's not obvious from the Ninth Circuit's own research and investigation what the answer to a particular legal question is, then they will send it back to the Washington Supreme Court and say it's called a certification, and they'll say, please answer these questions for us, because the Ninth Circuit is not the final decider on the meaning of Washington law, the scope of Washington law. The Washington Supreme Court is. So it's just kind of a way of deferring important legal questions to the body that has the ultimate authority to decide what the law is in Washington. And then it will apply the standard that the Washington Supreme Court says is the standard under Washington law. So the first certified question asks whether Washington law recognizes a special relationship between a university and its students, giving rise to a duty to use reasonable care to protect students from foreseeable injury at the hands of others. So right off the bat, going back to the claim that the plaintiffs made here, there was the allegation of the special relationship that WSU had with Bryan Kohberger. So the answer to that question is yes, and in the context of the questions presented, that relationship is defined and anchored in the common law as provided in Restatement Second of Torts, Section 344. Now remember, plaintiffs gave us 315A, 317, and 302B. Those were the grounds that they alleged had established the responsibility on the part of WSU to do something that, again, they allege would have prevented the murders from taking place. But the Washington Supreme Court has already said the special relationship is defined by this provision, 344, which is not addressed in the plaintiff's complaint. So right off the bat, we see this is potentially an issue. If you have to rely on a special relationship, the Washington Supreme Court has said this is the basis for that relationship. And why would they do that? This is important because the duty exists where a student is on campus, similar to a business invitee, or involved in university-sponsored activities. It means, quite frankly, that the university doesn't owe a duty to anybody and everybody on the planet. The reason why it owes a duty to potentially, non-students is because they came on campus where WSU is potentially liable, just like any other landowner is potentially liable under premises liability theories. This includes homeowners, tenants, and so forth. The idea is that if you're the one that's in possession of property, you have control over it, so you have the ability to make it reasonably safe for others who are, come to the property at your invitation, at your request, with your permission, and so forth. And so you can be liable if there's some dangerous condition on your property that injures somebody that is lawfully there. And this will come up with things like, you've got a weird threshold leading to your stairway that your family has lived there for decades, and so you totally don't even think about it anymore. You don't even notice it. But then you invite over a guest who's never been there, and you don't warn them about it, and they don't see it because it's not real obvious, and they trip and they fall down the stairs and get seriously injured. That is a kind of situation where the homeowner or the tenant, whoever is in charge of the condition of that property, can be potentially liable to that person that's been injured. So it's basic premises liability is the primary justification for universities having some kind of duty to others. And then the exception to that off campus is if they're involved in university-sponsored activities, because now you have control over what's going on, who gets to attend, what the activities are, and so forth. And so it's defining kind of the scope of control that universities have and for which they should be reasonably liable. Beyond that, the circumstances are kind of beyond their control, particularly when you're dealing with adults who have agency to be able to make their own decisions and, can choose to act in ways that you may or may not like. So we'll continue here. The second certified question asks, if yes to the first, what is the measure and scope of that duty? This question asks for the measure and scope of the duty, but we do not see any difference between the two words for the purpose of this question, and so have spoken to both in the same manner. The answer, as recognized by cases addressing this question, is that the duty exists within the campus confines or university-sponsored and controlled events. The scope of the duty is based on a student's enrollment and presence on campus. So how does this relate to the facts at issue and the particular allegations that we're dealing with in the plaintiff's complaint? The facts in this case kind of show us where there is some overlap. So in this particular case, they were both students, but the crime in this case, it was a crime, took place off campus. So not part of a campus-sponsored activity, just a private party that was held in an off-campus apartment. The perpetrator had been a student at WSU's Vancouver campus until spring semester 2017. While there, WSU received 2 complaints of sexual misconduct against him. One student made a complaint that he sent her sexual comments via electronic communication. Another student reported that while on a university bus for a school trip, he sat next to her and put his hands on and between her legs. He continued even when she told him to stop. So we also see factually, in terms of like the notice that the school was on, it's pretty bad. It's, from my perspective, significantly worse than the allegations that were made against Bryan Kohberger. These are physical assaults. This is, straight up sexual harassment. So at least in terms of the specifics that are outlined in the complaint, they don't rise to this level in terms of like what should the school have known, what did they know, and what should they have known, and what should they have done about it. The student reported the events to the school, and the Office of Student Conduct conducted a hearing and found him responsible for violating student conduct under these variety of student conduct codes. During the investigation, he requested to transfer to the Pullman campus, which was granted. As a result of the hearing on August 1st, 2017, WSU suspended him for 9 days and assigned him to write a paper on his understanding of consent. So now remember, going back, this is a few days, right? He gets, he has this hearing, he's requested to transfer. And so shortly after he transfers to Pullman, now he commits this new crime against a new victim. So not a whole lot of just distance, temporal distance but between the particular events. Pretty strong indication that whatever you thought was appropriate discipline here was very ineffective. On January 28, 2020, Barlow filed suit against WSU in the Superior Court for Thurston County, bringing a number of claims, including, most relevant for this analysis, a claim for negligence. WSU removed the claim to federal court. Barlow's negligence claim rested on WSU having a special relationship with its students, alleging a duty to both control and protect the students with the knowledge of the perpetrator's past sexual misconduct, making the harm foreseeable. By the way, the only reason I'm not saying the name is just because I don't know how to pronounce it. Coolhane, I'm not sure. So just the guy, the perpetrator, the guy who committed the crime. The negligence claim rested on WSU having a special relationship with its students because Bryan Kohberger himself is not WSU, except to the extent that he's an employee acting within the scope of his employment. Then you have classic respondeat superior liability. but that is limited to things that you are doing in the course of your work as an employee. So that's not being alleged in the family's case here. And I think credibly so. I don't think there's a particularly viable argument that he was on the job when he, committed the murders in Moscow. But that's why, in order to hold WSU responsible for what Bryan Kohberger did, Bryan Kohberger isn't them. So you have to have some other basis to say they need to be responsible for it. And so the basis is grounded in this idea that because of the relationship you have a special duty to manage that person, for lack of a better way of putting it. You have such a relationship that there is either a duty to protect the victims by virtue of your relationship with them, or there is a special duty to control the person who inflicted the harm. WSU motioned for summary judgment, arguing that Barlow's claims failed as a matter of law because her injury occurred off campus, where the school had no control and no duty. The district court granted the motion for summary judgment. Barlow appealed to the Ninth Circuit, and that court certified 2 questions regarding the negligence claim to this court. So WSU won at the trial court level. It's on appeal. This is our context. The Ninth Circuit is trying to decide, does she have a basis to go forward at all as a matter of law when the conduct that she has alleged took place off campus? So we know the certified questions analysis. I'm going to skip over this because it's just explaining the process for dealing with certified questions. So the general rule is that people and businesses have no duty to aid or protect others from harm. You don't have an obligation legally to be a good Samaritan or to be an intermeddler, to control other people's activity. Failing to act is generally not going to be something that makes you responsible unless it's a situation where you have a specific duty to act. Restatement Second of Torts, Section 315, acknowledges the same general rule, that there is no duty to protect others from third-party conduct, but outlines 2 exceptions, including when a special relationship exists between the actor and the perpetrator, or between the actor and the plaintiff victim. So 315A was the first basis that was cited in the complaint of the families. So they're going to deal with that first. Barlow argues that such a special relationship exists between students and universities and asks that we expand the common law duty of K through 12 schools to universities. She then proposes that we combine 2 related but distinct duties based on Restatement Second of Torts, Sections 315A and B, to establish that WSU had a duty to both protect her and control Culhane, the perpetrator. We have never recognized such a special relationship and duty between a university and its students. Rather, the proper analysis can be found in Restatement Second of Torts, Section 344. So they've already told us this. They've already said this in the introduction. They have rejected the argument that there is a special relationship under Section 315A, which is the very first basis that the plaintiffs relied on. They've said, that's not it, this is it. So here's what it is. Section 344 recognizes an exception to the general rule relevant here, which the state acknowledges exists. A possessor of land who holds it open to the public for entry for his business purposes is subject to liability to members of the public while they are upon the land for such a purpose, for physical harm caused by the accidental, negligent, or intentionally harmful acts of third persons or animals, and by the failure of the possessor to exercise reasonable care to A, discover that such acts are being done or are likely to be done, or B, give a warning adequate to enable the visitors to avoid the harm or otherwise protect them against it. This is based on business premises liability. If you are using your property commercially, you're inviting the public in order to buy your wares or services or so forth, you owe a duty to them to keep it safe and to not expose them to harm just because they want to come shop at your location. So it's kind of a cost of doing business thing. Well-established rule. The court is saying that's the basis for a university to have liability to third parties. Under this rule, a university, as a business operator and possessor of land, owes a duty and would potentially be liable to members of the public, including students who are on campus for school-related purposes. Section 344 creates a type of special relationship, but the duty is limited to university property and activities controlled by the university. They have a footnote here where they state this other section in the third restatement, section 40, also recognizes that all schools, including universities, have a special relationship with their students. However, comment L from that section states that, quote, as with the other duties imposed by this section, it is only applicable to risks that occur while the student is at school or otherwise engaged in school activities. Once you go home, school is much more limited in their liability, certainly a university. Little bit of a different situation with K through 12, which is what we're going to get into now. So Barlow first asked that we apply the duty to protect students established under our cases between K through 12 schools and students and expand that duty to universities. Our cases have developed a common law duty and special relationship with reference to restatement section 320 between K through 12 schools and their students, but no basis exists to expand that same level of special relationship to universities. The duty of K through 12 schools stems from the school's care and custody of the student. The fact that the child must attend school and the relationship is not voluntary, and the protective custody that teachers undertake being a mandatory substitution for that of the parent. Elementary school students are not independent. They are still vulnerable. They still need to be looked after and cared for. And we force them to go to school. We have truancy laws to compel them to be in this location under this supervision. And so because nobody has a choice about it and the kids need to be looked after, then the people we are forcing them to go and learn from have a responsibility to keep those kids safe. That's the nature of the duty. It's based on the dependence of the children, the needs of the children. And that's why it's going to be very different than dealing with adult university students who are not there because they are compelled to do so by law. University is a choice, K through 12 is not. But also because they are presumed to have their own agency now. You are adults, perhaps not as mature as you will ever be. But in terms of legal responsibility, you're 18 years old. You get to vote. You get to enter into contracts. You get to take on debt. Like you get to choose where you live. You get to make all of your own independent decisions. And so because of that, there is not a need for your school that you've chosen to attend to be responsible for you. Our cases rely on the nature of the relationship where K through 12 schools have almost complete control over their students and their activities to establish that duty. K through 12 schools generally operate as closed campuses, with the school monitoring closely all who enter the premises. That is certainly true today. Wasn't always the case. Definitely was not always the case, but very much is the case today. A K through 12 school has more ability to exclude members of the public as a safety precaution. Students' time on campus is carefully structured, controlled, and monitored, and they have little choice in class offerings. Kind of true, you don't get to just roam the halls at will when you're in grade school, however much you might want to do that. You got to get permission from the teacher and have your hall pass and all that. And if you get caught out by somebody else, might get sent to the principal's office. K through 12 schools control their young students and are standing in as parents during the school day, and that control gives rise to the duty that the school owes children. The same control and relationship does not exist in a university setting. Universities do not have similar protective custody over their adult students. University students are not under the complete control of the university or otherwise dependent in the same way as K through 12 students. Universities do not have mandatory attendance. University students have the ability to choose how to spend their time. The student can decide whether they will attend class in a traditional setting or online. Students choose what classes to enroll in and whether and when to attend. The class hours are often limited, and when not in class, students spend their time as they wish. They can take part in extracurricular activities, work, live independently, marry, take up hobbies, and choose with whom to interact. A university is distinct from a K through 12 school, lacking the requisite control over students' decisions. Another footnote here from the restatement, third section 40, also acknowledges that the duty owed to elementary school students is substantially different from that owed to college students. And because of the wide range of students to which it is applicable, what constitutes reasonable care is contextual. The extent and type of supervision required of young elementary school pupils is substantially different from reasonable care for college students. Barlow proposes that we look to restatement second, section 315b to establish the special relationship and duty of a university to protect its students. Though we have recognized special relationships and broad liability in some contexts, the cases do not support applying the duty of restatement section 315b to a university. Our cases have identified the nature of a Section 315b special relationship, giving rise to a duty under limited circumstances. For example, in Nice versus Elmview Group Home, we held that a group home had a special relationship with a vulnerable adult in its care. Based on the fact that Nice was totally dependent and unable to care for herself, and Elmview was fully responsible for her care, that responsibility gave rise to a duty to protect Nice from a wide array of harms. Again, it goes to dependency. If you can't take care of your own activities of daily living and somebody else has been entrusted to do that, then they assume the responsibility to do it properly and to do it well and to not be careless in how they perform their duties. Elmview's control was critical to applying the duty. That level of control simply does not exist here. Ms. Barlow was not a vulnerable adult lacking the faculties to care for herself. The university had no power to control her decisions or actions away from campus. The existence of a Section 315b duty requires control over a vulnerable person's actions, essentially a complete dependence in order to live. So it's got to be extreme before the court is going to say the university has such a responsibility to protect you that the fact that you suffer harm is like kind of almost per se proof that they fell short of being able to deliver that. We have more recently explained what creates a special relationship and rejected an invitation to broaden the common law duty. In Turner versus DSHS, we stated that Section 315b creates a heightened duty to protect someone in a situation where that person is helpless, totally dependent, or under the complete control of someone else for decisions relating to their safety. The duty is not based on custody, but on the dependence of the victim. Where this type of special relationship is formed, it is accompanied by a heightened duty of care to protect the person from any foreseeable harm, equating that duty to strict liability. If the relationship lacks the traits of dependence and control, we held that no liability exists. No similar duty exists between a university and its students under which a Section 315b special relationship is implicated. University students are not dependents. The university does not have a duty to keep you safe from the consequences of your own actions and inactions and so forth. Barlow emphasizes that the Section 315B duty is based on entrustment, that the school was entrusted with her care and she did not assume the risk of sexual assault when she enrolled in school. She states that failing to recognize the school's responsibility to care for her is essentially victim blaming. We place no blame on Barlow, but a lack of blame on the victim does not establish blame and duty on a third party. The blame lies on Culhane, on the perpetrator. So this is kind of a summary, a bit in a nutshell of kind of the grounds for establishing any kind of special duty that WSU had towards the victims. Now, we do have a factually somewhat different situation here where the victims were not students at WSU. So even if WSU had a duty to its own students and this analysis went differently, then the Washington Supreme Court said, actually, yeah, there is some duty on the part of a university to protect its own students, it still wouldn't apply on its face to that situation where you're not a student. So having a responsibility, a duty to protect a third party is going to be even more limited because you don't even have the argument that, you know, they have some sort of, you know, caretaking kind of equivalent responsibility towards you. So it's really about the control of Kohberger, and that's where this opinion is going to go next. So as an alternative to Section 315B, Barlow advances an argument relying on Section 315A and Section 319 to advocate for a duty on the part of a university to control Culhane, the perpetrator, based on what the university knew about him. We disagree. Such a duty does not apply here because of the nature of the relationship between a school and its students. So they're saying, even if you didn't have a duty to keep the victim safe, you had a duty to prevent the student from putting others at risk of harm. So the first part of this opinion has dealt with relationship between the student victim. This part is now dealing with the relationship with the student perpetrator. This is far more on point with what we're dealing with Kohberger because he was a student at WSU, and that's the basic allegation of the complaint is that WSU was on notice, knew that he was dangerous, didn't control him, didn't do something to address his behavior and prevent it from escalating. So on this argument, however, the Supreme Court has said, no, this duty doesn't apply here because of the nature of the relationship between a school and its students. In Volk versus Demirlier, we said that a Section 315 duty of reasonable care exists on a showing that a definite, established, and continuing relationship exists between the defendant and the third party. We also remarked that in order for a special relation under Section 315A to exist, the ability to control the third party must exist. We then held that a mental health professional and a patient have a special relationship pursuant to Section 315A, and thus the professional has a duty to take reasonable precautions to help any foreseeable victims. We acknowledged that the nature of the doctor-patient relationship gave the doctor insight into the dangerousness of the patient and provided the doctor with the identity of possible victims, but it also gave the doctor sufficient control of the third party to manifest the duty. Such a relationship does not exist between a university and its students, where interactions are far less intimate and consistent. Looking at this case, the university did not have sufficient insight into the potential dangerousness of Culhane. The university would not have been able to identify Barlow as a potential victim, and the university could not exercise sufficient control of Culhane to manifest the duty. This is likely the sort of 315 avenue to establishing a special relationship that the plaintiffs had in mind. And it's trying to equate the relationship that Bryan Kohberger had with his colleagues, his thesis supervisor, and so forth, with the type of relationship that a mental health professional has with their patient. And so this, I think, gives us a bit of an illustration about why that comparison is not likely to be persuasive. And it's because the whole purpose of the patient therapist relationship is for the patient to confess their deepest, darkest things. It's a relation of confidence for this very purpose. It's extremely similar to the lawyer-client confidentiality in that respect. The nature of the relationship means that people have to feel free to say bad things, to confess stuff they don't want anybody else in the world to know, so that they can get advice about how to handle it. So there is a degree of intimacy that's created by that confidentiality that just the whole point is to protect the person so that they can make those disclosures. You don't have that with your PhD supervisor, not even remotely. There's nothing that suggests that I would even consider telling my PhD supervisor my deepest, darkest secrets, because it's not their job. They may, in fact, have a duty to report me if I do that. So in this particular situation, this is the same standard that's going to apply to attorneys as well. Confidentiality is not absolute. And so when you have information that somebody is, like one of your clients tells you, I'm about to go, I'm on the doorstep, I got a knife, I'm going to do this thing, you have a duty to call the police. Confidentiality isn't going to protect that. And so it's the access, it's that special access that they enjoy that makes them foreseeable recipients of that type of information, that gives them a special duty to act responsibly, to protect others by virtue of the information that they receive. So this is not going to exist for general students, but the argument the plaintiffs, I think, are going to want to try to make is, well, this is beyond just Kohberger being a student. It's also being a PhD student, a TA, and having the thesis supervisor and all that. I don't think it's going to get them over this hurdle of it's not the same relationship. There's no confidentiality. That's not the purpose of it. There's just no reason to think that it would be foreseeable and likely that somebody who is anticipating committing a crime, for example, would go in and confess that to their thesis supervisor. But you can absolutely contemplate that somebody would talk about that with their therapist. In Volk, we also expressly rejected a Section 319 duty and noted the limitations that our prior decisions have placed on a take-charge relationship. As we have interpreted 319, a take-charge duty to act for the benefit of reasonably foreseeable victims exists in certain relationships, including the parole officer-parolee relationship, the probation officer-probationer relationship, and the corrections officer-community custody offender relationship. Section 319 has not been applied outside of the officer-offender context. So when you have arrested somebody, or you have, the ability to physically control them, then, you don't get to give them the rough ride, so to speak. Special relationship based on the power to arrest that these individuals enjoy. No indication that either, Bryan Kohberger's PhD supervisor, whatever, has the authority to arrest him. And certainly not that he ever was arrested. That would, create this type of relationship with, like, for example, the WSU police. Barlow has cited a number of Washington cases where an officer was found to have a restatement section 319 duty to the perpetrator's foreseeable victims. Drawing comparison to cases involving the officer-offender relationship is not helpful here. In those cases, the officer had significant control over the offender, such that the officer could dictate the movement and actions of the offender. Further, the officers had statutory authority to supervise those in their care, allowing officers to require offenders to report in, to impose conditions on them, and to generally monitor their behavior, a general power to control that a university cannot exercise. The university simply has no authority to dictate the actions of students away from campus. Now, remember, they have codes, right? They have conduct codes, and we've already established those codes do also apply to off-campus activity. So the fact that universities have rules of behavior for their student is not enough to say like that somehow translate this into the equivalent of the university being your probation officer. And so this is another area where Kohberger is trying to, the plaintiffs are trying to get Kohberger out of this situation and focus on the TA element of his employment with WSU, the benefits that he got from that. And so, because of that, there's a rental agreement that say that they can go in his house and they can monitor what he's doing on his internet and so forth. But it doesn't convert the nature of the relationship between Bryan Kohberger and the school to like the school being the equivalent of his probation officer. That's going to be the argument they're going to have to make. Supreme Court has already said we're really not buying it. We're not buying it with the case of just general students subject to codes of conduct, even if those apply off campus. So you're going to have a pretty big hill to climb if you're going to convince them that there's like, we're going to carve out this special category of student to make it more like a probation officer. Ms. Barlow has attempted to establish that based on what WSU knew about Culhane's past behavior, WSU must have had a duty to control him and protect her. She argues that the university had knowledge of his prior bad acts, and thus the negligence of the university was based on the foreseeability that Culhane would do harm again. However, foreseeability does not establish duty. Even if a party knows that a person may commit a crime against another, that party has no duty to act unless a special relationship exists with the victim or the perpetrator. Our cases have recognized such a special relationship in only limited circumstances, none of which apply in the situation presented here at an off-campus party. Making it very clear, general rule, no duty to act. No duty to act. And even if they thought it was possible that he might escalate, that's not enough. That's not enough. There's a lot of harms in the world that are foreseeable, but it doesn't mean you have a duty to act. If you are at the grocery store, out in the parking lot, getting into your car, and you see that there's somebody outside who appears to be distressed, maybe like homeless, mental health crisis, maybe intoxicated, kind of hard to tell, but just, behaving strangely and erratically. And you see that person is, maybe kind of veering towards traffic, towards like a busy arterial street or something like that. You don't have a duty to intervene. Doesn't mean you can't. Doesn't mean you shouldn't. But it doesn't mean you're legally responsible if you don't. The law does not require each and every one of us to be heroes. Frankly, some states, will penalize you for it. Some states have Good Samaritan protections and others don't. But this is just the general idea. You don't have a duty to intervene. It's only if you have some special responsibility for that person. If you were that person's social worker and you accompanied them to the grocery store, but then you got preoccupied, I don't know, talking to somebody that you know, reading a magazine from the rack, and the person that you're supervising wanders away and gets into trouble, now we might be in a different situation because you have some responsibility. You have a relationship with that person. You instituted the activity. You have knowledge of the vulnerabilities and the dependence of the person. You might be in a bit of a different situation then. So, issue here is just the fact of Kohberger being a student alone is not going to get him there. So they are having to try to carve out reasons why he's not just any student. He's a student plus. But the language that they've used here makes it extremely clear that they're very skeptical of that because they're grounding the scope of the duty in premises liability. It's just because you're on their campus or because there is some university-sponsored activity taking place off campus that the university is going to be held responsible. So they go through several cases from other jurisdictions, Massachusetts, Washington. And we'll pick up here at, what are we at, page 15. Last page before the conclusion. An assertion is made that because a university is involved in aspects of student life outside of the academic sphere, such as providing basic necessities, it is acting as a guardian or in the place of a parent. But the examples of non-academic offerings noted, on-campus housing, providing food, opportunities for social interaction, generally occur on campus, where a university has potential liability based on Section 344. So this is, again, getting back into the plaintiff's argument that because they provided him with on-campus housing and because that relationship gave them certain rights to enter the property, search it, go through his internet activity and so forth, that therefore they had like a duty to do that extended to non-student victims off campus. That's not going to support the claim here because it's not a harm that arose on campus. Also, it is argued that because a code of conduct exists that addresses off-campus behavior, the university is taking measures to control that behavior, and its duty should also extend off-campus. So a lot of emphasis the plaintiffs put on all of these variety of codes and duties and policies and restrictions and so forth that Kohberger was subject to, even off campus. But they disagree that that creates a duty. The code of conduct does not create control of students' behavior in a preventative way. The code may provide the university the ability to academically punish students after the fact with suspensions, academic probation, or even expulsion. The code of conduct is irrelevant to establishment of a duty. So it's the difference between I can discourage you from doing something because I can threaten you with punishment for it versus I have a duty to stop you from engaging in that activity in the first place. This is where the reliance on the codes is not going to get them anywhere, because the fact that they can respond and could have done the things that the plaintiffs are arguing they should have done, sent him to counseling, put him on probation, fired him, kicked him out of school, doesn't mean they have a duty to do those things. The power doesn't equate to a responsibility. While sexual assaults are horrific, a university simply has no power to dictate students' movements off campus away from the oversight of campus security and administration. It's kind of the bottom line. The university doesn't have the power to stop somebody, a grown adult in their program, from driving to Utah and murdering people in their home. While a special relationship exists between a university and its students, that duty is to use reasonable care as recognized in Section 344. Because no ability to control off-campus, non-school sponsored interactions exist, the duty does not extend to the choices or activities under a student's control. A university's duty is limited to where a student is on campus for school-related purposes or participating in a school activity. So these don't exist in our case. This did not happen on campus. This was not part of a school-related activity. As such, Barlow seems to make it pretty crystal clear that there's not going to be an avenue for them to find a special duty either to the victims in Idaho or a duty to control Bryan Kohberger. Now, remember, there were two other grounds that the plaintiffs asserted as bases for saying that there's a special relationship, 317 and 302B. And this opinion doesn't address them, but this opinion also pretty strongly forecloses them because it says this is the basis. So they're in a really defensive position with being able to get this case to move forward, with respect to this negligence claim. Basic requirements to proceed in negligence, learn it in law school: duty, breach, causation, damages. You must have a duty. You must establish a duty to act. Otherwise, failing to act is not something you can be legally responsible for. And the existence of a duty is something that the judge decides as a matter of law based on the facts that you've pleaded. You don't get to just, allege that there is a duty and therefore that gets taken as fact. That's a legal conclusion that the court gets to draw. So in the absence of a duty, there is no liability. And under Barlow, it seems pretty clear that the university doesn't owe a duty in this situation. So they are going to be on the back foot trying to justify, why Barlow doesn't control, why they have alternative theories that weren't foreclosed by Barlow and so forth, why Bryan Kohberger is in this, special middle ground, whereas the TA, he's different from a regular student. But the problem is that what they're kind of doing through that is just conflating special relationship responsibility with respondeat superior, the liability of the employer. And so, either one of those is going to foreclose relief from them because there's no question he wasn't acting as an employee when he committed the murders. This is not part of his job, not something that is within their zone of control. But clear under Barlow, the fact that he's a student alone isn't going to be enough to establish a duty. So they're trying to carve out like this special middle ground that kind of draws on both of those, when Barlow has made it clear this is all grounded in the basic responsibility that a business owner has to keep their property safe. So based on that, guys, the negligence complaint, I don't think it is really going to go much of anywhere. Highly likely that we're going to be seeing a motion to dismiss it, and that motion to dismiss will be granted. So then Let's move back now and look at the Title IX claim. So Title IX claim is a little bit different. It's also, quite long, but it's a lot of the same basic allegations. They seek to hold WSU liable for its own decisions and actions to remain idle in the face of known extreme and repeated instances of discrimination, sexual harassment, and stalking by Kohberger occurring in its educational program throughout the entirety of the fall 2022 fall semester that ultimately culminated in Kohberger's stalking and murdering the decedents. WSU receives federal funding, so they're subject to Title IX. Title IX prohibits sex-based discrimination, including sexual harassment and stalking, in federally funded education programs. Title IX liability arises where the university had substantial control over both the harasser and the context in which the harassment occurred, and that the university acted with deliberate indifference to known acts of discrimination. The U.S. Supreme Court has recognized that these conditions of control are satisfied most easily and most obviously when the offender is an employee of the university. Similarly, Title IX liability arises where the offender is under the university's disciplinary authority in the setting in which the harassment takes place. There's a private right of action under Title IX, allowing individuals to seek monetary damages for intentional violations of the statute, including deliberate indifference to sexual harassment and stalking. Liability arises when the university has actual knowledge of the discrimination and acts with deliberate indifference to it. Liability also extends to third-party misconduct when the university's deliberate indifference effectively subjects individuals to discrimination or harassment, including stalking, even if that harassment takes place off the physical property of the institution. So we can already see just from the allegations, there is a little bit of a broader responsibility under Title IX to third party. Washington law has said we're pretty much focused on liability to third parties happening on campus. It's because you came on campus, the school has the responsibility to keep the campus safe. Or if the school goes off campus but is sponsoring activities, then things that are happening in the course of those activities, they can be responsible for. And because it's just based on the degree of control that they're assuming. But this is broader. This is suggesting that liability is broader under Title IX because it reaches beyond the physical property of the institution and it reaches beyond people that are themselves students, employees, so forth, members of the educational environment. The evidence demonstrates that one or more responsible WSU officials exercised sufficient control over the context in which Kohberger stalked, planned, and ultimately attacked the decedents to support liability under Title IX. The evidence further demonstrates that WSU had actual knowledge of facts that required an appropriate, comprehensive, and urgent response, and that WSU's failure to escalate and or properly, decisively, and urgently act upon reports of Kohberger's actions was a clearly unreasonable response that demonstrated WSU's deliberate indifference. As explained further above, WSU had substantial control over Kohberger as an employee of the university. WSU had the ability to pre-employment vet him, do a background check, require a sexual misconduct declaration. After they hired him, they also had control over his training, including mandatory human resources, discrimination, sexual harassment, and sexual misconduct prevention training. After hiring him, WSU also had control over his supervision and specifically assigned WSU faculty to serve in that capacity. He was subject to numerous policies and procedures. A lot of this, we already know from going over the allegations for the negligence claim, both on and off campus, including periods when the university classes were not in session. Through its unique employment and financial relationship with Kohberger, WSU exerted substantial control over his conduct by providing him with benefits, all of which was conditioned on his good behavior and which WSU could revoke. had substantial control over the context in which he was repeatedly and continually behaving in a discriminatory, harassing, and stalking manner. The offending behavior occurred in WSU classrooms, during instruction, and in the presence of faculty as early as the first week of the semester. Kohberger's offending behavior also occurred outside of the classroom, but in the halls and offices of the WSU Criminology Department. Kohberger's offending behavior also occurred in the course and scope of his employment with WSU, including but not limited to preying on undergraduate students and fellow WSU graduate students and employees. Kohberger's offending behavior occurred throughout the WSU campus as he harassed female employees in the campus bookstore and followed female students and employees to their cars, inciting fear for their safety and necessitating escorts by faculty and police for security. WSU faculty, staff, and students were also aware that Kohberger was engaging in harassing, stalking, and predatory behavior off of the WSU campus, but in the Pullman-Moscow community. Kohberger's offending behavior also occurred in a context that should have triggered urgent action by WSU's threat assessment team, and WSU had the ability to take such urgent action to mitigate the imminent threat that Kohberger posed. Kohberger was also under WSU's disciplinary authority in the setting in which the harassment took place, and WSU had the authority to take remedial action. Remedial action. This is hearkening back to what they just said in the Washington case, that this is not the same thing as preventative action. Remedial action is dealing with it after the fact. Doesn't necessarily mean you have a duty to stop it in the first instance. But anyway. Policies and procedures, including those that required him to act with the highest degree of professional conduct and not to discriminate, harass, and stalk, allowed WSU to take remedial action if Kohberger engaged in violative behavior that occurred either on or off campus. WSU had the ability to punish Kohberger for his behavior. WSU only took sporadic, minor, and ineffective action to address Kohberger's inappropriate behavior, including informal discussions with faculty, putting him on a brief, vague, and non-specific 4-point personal improvement plan, and mandating that all graduate students participate in remedial discrimination and harassment training which Kohberger was observed to conspicuously ignore. WSU had the ability to take action against Kohberger through its Compliance and Civil Rights Title IX office, but despite receiving 13 formal complaints, WSU CCR apparently took no meaningful action, and the individual responsible for acting on such complaints admitted never having met or even spoken with Kohberger. WSU had the ability to take action against Kohberger through its threat assessment team, but there is no indication that any such action was taken by WSU. WSU had the ability to terminate Kohberger's employment, eliminate his funding, remove him from campus housing, and eliminate access to the WSU ResNet internet network. WSU ultimately did terminate Kohberger's employment and eliminated his funding, but not until after he had murdered 4 young students. Of course they did. Of course they did. But that's because it's quite an escalation from the types of things that he was accused of while he was on campus. Quite short of murder. Only after Kohberger's arrest for the murders did WSU finally serve Kohberger with a trespass admonition prohibiting his presence at WSU. Before the murders, WSU had substantial actual knowledge and notice of Kohberger's extensive and repeated instances of discriminatory, harassing, and stalking behavior. There were numerous discussions among WSU graduate students, teaching assistants, faculty, and staff about Kohberger's discriminatory, harassing, and stalking behavior. The members of the WSU Criminology Department, most if not all of whom were mandatory reporters, were tracking Kohberger's inappropriate behavior but failed to properly inform and alert WSU administrators. Ultimately, however, WSU received at least 13 formal complaints of discriminatory, harassing, or stalking type behavior by Kohberger that were presented to a WSU administrator whose duties are to address such complaints. But there is no indication that WSU acted on those formal complaints or that it acted in an urgent and decisive manner commensurate with the imminent and serious threat that Kohberger posed. WSU faculty recognized the need to stage an intervention on Kohberger very early on and months before the murders, but failed to ever do so. Kohberger's supervisor at WSU even advocated that disciplinary action not be taken against Kohberger out of fear that he would sue WSU, thereby putting the financial interest of the university above the safety of the Pullman Moscow community. WSU also exercised significant control over Kohberger and the environment in which the harassment occurred by implementing an official policy that tolerated sexual misconduct, harassment, and stalking, and discouraged complete and accurate reporting of occurrences of misconduct. The official policy that tolerated sexual misconduct, harassment, and stalking is evidenced in part by the fact that during the 2022 fall semester, WSU's own investigation determined that the WSU Police Department, a department responsible to prevent and intervene in instances of such misconduct, had itself engaged in numerous incidents of sexual misconduct and fostered an environment that discouraged reporting of sexual misconduct. Despite being aware of specific reports of inappropriate and alarming behavior, WSU allowed Kohberger's discriminatory, harassing, and stalking behavior to continue unchecked and provided him with a target-rich environment where that behavior was tolerated and allowed to escalate, including but not limited to continued interaction with a female undergraduate students in a supervisory capacity as a WSU teaching assistant, a salary, on-campus housing with free internet, medical benefits, and free tuition. Recognizing the potential and serious danger that Kohberger posed, WSU police provided safety escorts to female students and employees, but did not intervene directly with Kohberger or perform any proper threat assessment, which served to embolden Kohberger. Evidence also indicates that Kohberger engaged in stalking behavior and preparatory acts as it relates to the decedents, both on WSU property and using WSU resources. WSU provided on-campus housing to Kohberger at the Steptoe Village Apartments. WSU also provided Kohberger with free internet access through WSU's control network called WSU ResNet, on which WSU retained the right to monitor usage and take remedial action if used for inappropriate purposes. The numerous red flags in Kohberger's behavior should have led WSU to monitor his online behavior, and had WSU done so, it would more likely than not have discovered that he was using the WSU ResNet internet network for inappropriate purposes. Evidence indicates that Kohberger had engaged in stalking behavior of one or more of the decedents for months before he committed the murders. After the murders, a forensic examination of one of Kohberger's computers revealed that during his time at WSU, he had performed many deeply troubling internet searches about serial killers, home invasions, co-ed killings, and pornography depicting non-consensual sex. Kohberger, however, made significant efforts to delete his computer activity in the month before the murders, which forensic examiners believe was a deliberate attempt to conceal his plotting, planning, and stalking of the decedents. Had WSU been monitoring Kohberger's use of the ResNet internet network, it would have been aware of these efforts to plot, plan, and stalk the decedents. Additionally, WSU possessed information about Kohberger's use of ResNet in the form of server logs and other user data that would have remained in WSU's possession despite any efforts by Kohberger to delete and conceal his internet usage. Reports indicate that Kohberger had been stalking one of the decedents on social media, and to the extent that occurred through the WSU ResNet network, it is violative conduct that occurred on the WSU campus. Kohberger also possessed the murder weapon for months before the murder. It was a violation of WSU policies and the apartment agreement for Kohberger to possess the murder weapon in his own on-campus apartment, and WSU had the ability and right to inspect his apartment and remove Kohberger for such a violation. Kohberger's repeated alarming and menacing behavior should have caused WSU to inspect his apartment as it had the right to do under the apartment agreement, and had it done so, WSU likely would have discovered the K-bar knife in violation of the apartment agreement and WSU policies. WSU's response to Kohberger's behavior and the numerous complaints raised by WSU students, faculty, and staff was clearly unreasonable. Title IX liability also arises when discrimination and harassment is so severe, pervasive, and objectively offensive that it deprives victims of access to educational opportunities or benefits. Kohberger's discriminatory and harassing behavior was so extreme, pervasive, and objectively offensive that female classmates would flee the classroom in the middle of instruction, leaving their possessions behind. Well, this was one. Putting this in the plural is not quite what they alleged. Female students, staff, and faculty felt threatened and scared by his aggressive staring, looming behind them and uncomfortably close, physically blocking their exit and following them to their vehicles, necessitating routine security escorts. So this is kind of the closest we get to in this section anyway of kind of getting into what is the basis for these allegations that Bryan Kohberger alleged in menacing and predatory and stalking type of behavior, harassing type of behavior. He stared at people a lot. He got too close and stayed there too long. Not a good respect for personal space. Blocked the exits of the door. Would come into the offices and like stand at the door so people inside couldn't get out, and then following people to their vehicles. So just hearkening back to the beginning when I started here, there are both favorable, generous and ungenerous ways to view these allegations. But that's ultimately what they're saying. This constituted the behavior that should have put WSU on notice and now put them under a duty to act, not based on negligence responsibilities, but based on Title IX responsibilities. The decedents, Gonsalves, Mogan, Kernodle, and Chapin, all students at a federally funded university in the same community, were also deprived of and permanently denied access to educational opportunities and benefits when Kohberger stalked them, planned his attack, violently assaulted them, and ultimately took their lives. WSU's acts and omissions alleged herein with respect to the discriminatory, harassing, and stalking behavior of Kohberger against multiple female students deprived students of the full benefits of their educational program on the basis of sex in violation of Title IX. WSU failed to exercise its supervisory power and disciplinary authority over Kohberger despite having repeated notice of the high risk of serious misconduct. The likelihood of Kohberger engaging in future and escalating misconduct was so obvious that WSU's failure to act was the result of deliberate indifference. Just got to point out, if this gets to a trial, that's going to be something that they have to prove, that staring at people and invading their personal space made it so obvious he was going to commit the murders that handling it the way that they did meant they were deliberately indifferent to the potential for the result that came about. So there's a lot going on there in terms of foreseeability, in terms of causation, in terms of all of that. But yeah, those are going to be factual issues if this gets to a jury. WSU had the ability but failed to take timely, appropriate, and decisive action that would likely have prevented the harassment, stalking, and murder of the decedents. Causation is going to have to be a fact question for the jury if they get to that point. What's the proof that anything WSU did would have stopped it? They're in this kind of awkward position factually, where on the one hand they're suggesting he'd been doing this for months, right? If assuming their allegations are true, as we do in this context, let's say they can prove that he did in fact stalk the decedents or one of them for months, even though Bill Thompson said repeatedly that didn't happen. Let's say they did. Let's say he did. What do they have the ability to do about it? What do they have the power to do about it in light of what he actually is alleged to have done at WSU, which is not criminal? Okay, this is not the situation like the Barlow case where the guy committed criminal acts. Sending somebody unwanted sexual content, and then physically molesting somebody. These are crimes. Staring staring uncomfortably at people. What do you have the power to do about that? Like, there's this kind of implication that had they dealt with the staring, they would have looked at his internet activity. I mean, I'm just not necessarily seeing the link there, but let's say they did. So they would have looked at his internet activity because he was stalking them. They would have seen that he was stalking them. And so they would have expelled him. But how do we know for sure that would have stopped him from carrying out the plan that according to their own theory of what transpired here had been put in motion months before? I don't know. Causation is going to be a challenge in my view, but that's a fact question. That's dealing with a jury down the road. WSU's acts and omissions alleged herein caused, in fact, and substantially contributed to the stalking, assault, and murder of decedents. WSU acted with deliberate indifference to known acts of harassment and stalking against female students in connection with its programs or activities that it was in a position to address appropriately and therefore may be held liable for damages under Title IX. So the context that we have here, there's a little bit of conflation going on, like kind of trying to go on, because Kaylee, Madison, Xana, and Ethan were not students at WSU. They were students at another school. And so they are kind of third party with respect to these incidents of harassment that the Title IX claim is based on. They didn't themselves experience any of these unpleasant staring and things like that interfered with their own educational opportunities. So they have to get this in a framework where not dealing with Kohberger's, let's assume it's violative of Title IX activity on the WSU campus, caused off-campus behavior for which WSU can be liable. Believe it or not, there is some case law on this. People have tried it. And so this came up in the Ninth Circuit. In this case, Brown versus Arizona. This is, I want to say 2003. Went up to the U.S. Supreme Court on a petition for certiorari that was denied. So a Supreme Court declined to look at this decision and ultimately let it stand. So we, of course, in Washington are in the Ninth Circuit. This is going to be the binding law that will apply in federal court in dealing with a Title IX claim under these circumstances. So we have a case where a person attending the University of Arizona on a football scholarship repeatedly and violently assaulted his girlfriend and fellow student over the course of several months in the summer and early fall of 2016. The last assaults were extremely violent. They took place on 2 successive nights in September during Bradford's sophomore year in an off-campus house where Bradford was living with other university football players. Bradford and the other football players were allowed to live off campus only because the coaches of the university football team had given them permission to do so. That permission was conditioned on good behavior. At the time of Bradford's assaults on Brown, university officials knew that Bradford had repeatedly and violently assaulted 2 other female undergraduates during his freshman year. Despite this knowledge, those officials did not take steps to ensure that Bradford would not be a danger to Brown and other students. Undisputed evidence in the record shows that if Bradford's coaches had been told of his assaults on the 2 other students, Bradford would have been kicked off the football team, would have lost his athletic scholarship, and likely would have been expelled from the university by the end of his freshman year, months before his assaults on Brown. So already we got a lot of factual overlap with the types of allegations that are made in the plaintiff's complaint. The one distinction here is the fact that the girlfriend is a student, and the victims in the Idaho 4 case not students of WSU. We're going to see how, at least according to this case, that is ultimately not going to matter. Brown sued the university under Title IX of the Education Amendments of 1972, contending that the university's actions and omissions in response to Bradford's violent assaults on 2 other female students deprived her of the full benefits of her education, and that an appropriate response would have prevented Bradford's assaults on her. For simplicity, this opinion refers to all defendants collectively as the university. The district court granted summary judgment to the university, holding as a matter of law that the university did not exercise control over the context in which Bradford's abuse of Brown occurred. A divided 3-judge panel affirmed in a published decision. So important context here. This is coming up on summary judgment. This is not coming up on the pleadings. So this is a situation where the factual record has been developed and basically given certain undisputed facts, legal conclusions about the nature of the relationship and the control and so forth can be made as a matter of law. So in the pleadings context where we're at with the plaintiff's motion here, or the plaintiff's complaint here, should WSU argue that the duty doesn't arise as a matter of law, they can do that, but it's going to be based just on the allegations. And so this is why, again, we're taking the allegations as true. Okay, if everything that they say is true, then we have facts that we can deal with, and then we can apply this principle from the summary judgment context to tell us, are those facts going to be sufficient to establish grounds for Title IX liability here? We hold that Brown presented sufficient evidence to allow a reasonable fact finder to conclude that a responsible university official exercised sufficient control over the context in which Bradford attacked Brown to support liability under Title IX. We further hold that she presented sufficient evidence to allow a reasonable fact finder to conclude that the university had actual knowledge of facts that required an appropriate response, and that a university official's failure to escalate reports of Bradford's actions was a clearly unreasonable response, demonstrating the university's deliberate indifference. So already starting to see where they are drawing the language from that they used in the complaint. Clearly unreasonable, the deliberate indifference, the actual knowledge. These are all relating to the legal standard. That's why they're using those words. So in this case, it's allowed to go forward. They say it's enough because the university official exercised sufficient control over the context in which Bradford attacked Brown. So we're looking at the context of the subsequent events, not necessarily the first one. So we'll get into how that all works. So we don't need the detailed description of the facts because we already know the general gist of it. There were violent assaults. The school knew about it. The school didn't particularly do much about it. He stayed on the football scholarship. The girlfriend started dating him, and then ultimately got seriously assaulted and filed the Title IX claim, arguing that how they handled the previous assaults was insufficient. So this is a little bit of procedural history that we don't necessarily need either, because we already kind of know, but the basic argument here is the circumstances of the case in which the university had extensive authority over Bradford, including control over whether he could live off campus. The university had substantial control over the context in which he assaulted Brown. So they are going to address this narrow question. Standard of review, summary judgment. You infer everything to the benefit of the non-moving party, kind of like we did here, and look at the law de novo, independently. Subject to exceptions not relevant here, Title IX provides no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. these cases, Gebser and Davis set out the guideposts for liability under Title IX. To obtain damages under Title IX for student-on-student harassment, a plaintiff must show, 1, that the educational institution had substantial control over both the harasser and the context in which the known harassment occurs. 2, that the harassment was so severe, pervasive, and objectively offensive that it denies its victims the equal access to education that Title IX is designed to protect. 3, that a school official with authority to address the alleged discrimination and to institute corrective measures has actual knowledge of the discrimination. 4, that the school acted with deliberate indifference to the harassment. And 5, that the school's deliberate indifference must, at a minimum, cause students to undergo harassment or make them liable or vulnerable to it. Substantial control over both the harasser and the context in which the known harassment occurs. It's so severe, pervasive, and objectively offensive that it denies the victims equal access to education and had authority and actual knowledge, but acted with deliberate indifference that caused even more damage. So we're going to look at what that means. Substantial control over the context. What the hell does that mean? What is the context? What is substantial control? This is one of these extremely nebulous standards that kind of sounds wise and prudent, but in the actual, like, what the hell does it mean? It seems very flexible because context of the harassment, I mean, it just seems like a framework that you can draw as broadly or as narrowly as you kind of want to. So we need a little bit more to understand what on earth does this mean? So that's what they're going to give us here. What do they mean by this? The Supreme Court held in Davis that a damages remedy is not available under Title IX unless the defendant had substantial control over both the harasser and the context in which the harassment occurred. So this is roughly equivalent to saying under Title IX, they have a duty. Okay, it's separate from the negligence duty. Title IX imposes on universities a duty to prevent sexual harassing, discriminatory type of behavior if they have control over the harasser, which is typically either a student or an employee, and the context in which the harassment occurred, the context. The plaintiff in Davis had been sexually harassed by another student at school. The court held that the school could be liable for failing to respond to complaints by the plaintiff and other students about the conduct of the harasser. The court limited a school's liability for student-on-student sexual harassment, however, to circumstances where the school exercises substantial control over both the harasser and the context in which the known harassment occurs. Justice O'Connor wrote for the court, the statute's plain language confines the scope of prohibited conduct based on the recipient's degree of control over the harasser and the environment in which the harassment occurs. Because the harassment must occur under the operations of a funding recipient, the harassment must take place in a context subject to the school district's control. So, got a lot going on with how that intersects with the complaint here, because the complaint is dealing with a lot of different situations and trying to kind of tie them all together. They have, on the one hand, Bryan Kohberger's on-campus activity, his use of campus resources, things that he's doing in his campus housing, his behavior towards students on campus. And all of these things are situations where the school has some degree of control over that. But our victims here didn't suffer the harm they suffered in that context. They were somewhere completely different. not part of the school, not part of the school activity, none of that. And so what the complaint has done is tried to kind of merge those requirements by focusing on Bryan Kohberger's on-campus activity as the relevant context, and saying because they had control over his housing and stuff like that, they are making that equivalent to control over the context in which the murders took place. So this is why they're doing that, right? Because this is the standard. This is the standard that we deal with. If you're going to succeed in a Title IX claim, you got to show the court had control over the school had control over the context. But you have a problem with your facts that this was non-students off campus. And so that's how they're trying to draw the connection, is by kind of drawing it as though the murder is an inevitable continuation of the harassment that took place in the area where the school had control. And so therefore, it kind of like more or less took place within the zone of control of the university. Little bit challenging. So the court in Davis did not define context, but its meaning may be inferred from several passages in its opinion. First, the court explained that where the harassment occurs during school hours and on school grounds, the misconduct takes place under an operation of the school. Second, the court cited with approval a Seventh Circuit case in which the court had found liability where the school failed to respond properly to student-on-student sexual harassment that takes place while the students are involved in school activities or otherwise under the supervision of school employees. Finally, the court articulated its holding on the control element. We thus conclude that recipients of federal funding may be liable for subjecting their students to discrimination where the recipient is deliberately indifferent to the known acts of student-on-student sexual harassment, and the harasser is under the school's disciplinary authority. So again, we have this kind of reference to the student's relationship, the presence on campus, the control of the supervisors, and the location of where the stuff is happening, all being potentially relevant. And so, based on the way that the plaintiffs have set out their complaint, it seems really clear that the students at WSU who filed the reports, those students have potential claims. They fall squarely within the student-on-student harassment. It took place on school grounds. It took place using school resources. It took place in the context where the PhD supervisor is supervising, the faculty is receiving reports and communicating about it, and so forth. If we were just talking about that context, I think it'd be pretty clear that, yeah, this case by these students is likely going forward. But that's not the total context, right? That's the problem that we have here, is these people that are outside of that context. Can the school be liable because they didn't control the context they did have control over, and it created harm in another context? That's going to be the challenge that they have to establish. These passages make clear that while the physical location of the harassment can be an important indicator of the school's control over the context of the alleged harassment, a key consideration is whether the school has some form of disciplinary authority over the harasser in the setting in which the harassment takes place. So this shows us why they are focusing so much on all of these different policies and the contracts and the different methods that the school had to monitor Kohberger and intervene in his activity and so forth. Because if they can control it, then even if it takes place off campus, they might still be responsible for it. So location can be important, but the issue is in determining the context is basically what's their ability to control it. So there's a quote, I'm not going to read there, but the setting could be a school playground, but depending on the circumstances, it could equally well be an off-campus field trip, an off-campus research project in a laboratory not owned by the school, or an off-campus residence. If the harassment occurs in such a setting, that is, in a context over which the institution has substantial control, the institution may be held liable for deliberate indifference under Title IX, even though the harassment takes place off the physical property of the institution. So much broader here than the negligence duty under Washington law, which is grounded in that idea of premises liability. Title IX says if they control the context, then even if the actual setting is off campus, that's not going to be definitive. In the case before us, it is clear that the university had substantial disciplinary control over Bradford, the harasser. The disputed question is whether it had substantial control over the context in which the harassment occurred. Fortunately, we do not write on a clean slate. Engaging in fact-specific inquiries, a number of courts have concluded that liability attaches under Title IX when harassment occurs off campus, so long as the educational institution has sufficient control over both the harasser and the context in which the harassment takes place. So we've got some other cases here that they're relying on. This one out of Colorado. Again, it's students who were assaulted in an off-campus apartment by members of the university football team, as well as by high school students who were there to be recruited. And the court held there was a substantial control over the context, even though this took place off campus, because of the nature of the activities they were engaged in. So the Colorado University football team recruited talented high school players each fall by bringing them to campus. Part of the sales effort was to show recruits a good time. To this end, recruits were paired with female ambassadors who showed them around campus and player hosts who were responsible for the recruits' entertainment. And at least some of the recruits who came to the plaintiff's apartment had been promised an opportunity to have sex. So in this particular case, the 10th Circuit said that's enough. Implementation of an official policy can certainly be a circumstance in which the recipient exercises significant control over the harasser and the environment in which the harassment occurs. And viewing the evidence in the light most favorable to the plaintiffs, the court held that the university had a policy of showing recruits a good time. The assaults were caused by the university's failure to provide adequate supervision and guidance to player hosts chosen to show the football recruits a good time, and that the likelihood of such misconduct was so obvious that the university's failure was the result of deliberate indifference. So, in short, this case made it clear that a university can exercise substantial control over an off-campus context when it facilitates the presence of both the perpetrators and the victims of the sexual violence at the site, and chooses to minimize its own oversight of their activities and thus increases the risk of assault. Not really equivalent to our situation with the King Road house, because it wasn't anything that the university facilitated in any way at all. So we've broadened it to the point that we can take it off campus based on the ability to impose discipline and arrange, kind of having set up the whole thing in the first place. But that's not our facts. WSU did not set up Bryan Kohberger going to the King Road house. In this case, out of the Fourth Circuit, a student organization, Feminists United, had spoken out against a student Senate vote to authorize male-only fraternities at University of Mary Washington. UMW students debated the issue through anonymous posts on YikYak, a social media platform that allowed users to communicate with each other within a 1.5-mile radius, such that the harassing and threatening messages originated on or within the immediate vicinity of the UMW campus. Between November 2014 and the summer of 2015, UMW students posted hundreds of harassing messages on the YikYak platform, many threatening physical and sexual violence against members of Feminists United. So now we are off campus in a bit of a different way. We are online. We are in the digital world. And so the Fourth Circuit held that UMW had substantial control over the context of the harassment conducted over YikYak, as the harassing and threatening messages originated on or within the immediate vicinity of the UMW campus. Even though the offending posts on YikYak were anonymous, plaintiffs contended that UMW exercised control over the context of the harassment because it had some ability to identify the harassers. If the university had pinpointed the harassers, it could then have circumscribed their use of UMW's network. The court discussed the range of other remedial measures that the university had at its disposal. The university could have disabled access to YikYak campus-wide. UMW administrators could have more clearly communicated to the student body that the university would not tolerate sexually harassing behavior. The university also could have conducted mandatory assemblies to explain and discourage cyberbullying and sex discrimination. And the university could have provided anti-sexual harassment training to the entire student body and faculty. In other words, the feminist majority court held that a university has substantial control over an off-campus context when it has the ability to take actions that would likely prevent harassment in the immediate vicinity of the campus. So now we're getting closer. TikTok or YikYak. YikYak, control over YikYak. Not because they have any actual control over YikYak, but because they have some ability to monitor who is using the university network. And so they could have checked the logs and things like that, seen who's logging into YikYak, who's posting things on YikYak at various times and things like that. Haven't given us a real strong factual outline of the nature of the control. But this is getting a lot closer to having control over a completely off-campus apartment if you had the ability to do something that would have prevented harassment in the immediate vicinity of the campus. It's getting closer. Is King Road going to count as the immediate vicinity of the campus? The plaintiffs have done a lot to try to conflate the Pullman Moscow community, and they're basically neighbor schools, and they have study abroad programs at each other. They sometimes like work together, like they want to really try to bring this together as if it's pretty much the same school, although it's definitely not. But I think this is likely why. Trying to get it closer to the immediate vicinity of WSU. In this Kansas case, the plaintiff was a female student at KSU. She alleged in her complaint that she attended an off-campus fraternity event where she became intoxicated. She was assaulted in front of a bunch of students. He then drove her back to his off-campus fraternity as a house and assaulted her on the way. When they arrived at the fraternity house, he did it again, left her alone, naked, and passed out. And another KSU student and member of the fraternity did it 2 more times. Pretty gross. The university refused to discipline JF and JG on the ground that they had taken place off campus. She had a lot of harm, which I can certainly understand. The district court held that the university had sufficient control over the off-campus contexts to warrant Title IX liability. In support, the court cited a number of factual allegations in the complaint. KSU fraternities were open only to KSU students. The director of the fraternity at issue was a university instructor. The university promoted its fraternities to prospective students and parents. The university had 5 employees specifically charged with supporting and advising fraternities and sororities. The university had the authority to regulate fraternities, including promulgating rules for parties. The dean of student life approved the suspension of the fraternity for its use of alcohol at the party where these events took place. In sum, the oversight of the relevant organization by a school staff member, regulatory authority by the school, and strong affiliation of the fraternity with the school were sufficient when considered together to establish control over the off-campus contexts. Less close again. Now we're still off campus, but we're off campus in a building, in an environment that is still at least somewhat affiliated with the school, the fraternity building. So really not equivalent to the King Road house. In a case out of California, the court held that a school had substantial control over the context where upper-class teammates sexually assaulted and harassed the plaintiff at an off-campus summer football camp. The court so held because the camp was sponsored and promoted by the high school and the district's coaches. The players were supervised at the camp by district employees. The camp was governed by a district administrative directive that outlined supervision ratios and disciplinary procedures. So we're just, again, in a situation where it's an off-campus context, but the school is controlling what's going on there. It's a camp that the school is running. This is like the equivalent of the school-sponsored activities. So we still have not gotten to a situation where harassing somebody, harassing people in a context over which the university had control is going to subject the university to liability for harm against unrelated people, different people, non-students, in a different context over which the school had no control. In the case before us, the district court held as a matter of law that the university did not have substantial control over the context in which Bradford's September 12 and 13 assaults on Brown occurred because the assaults took place off campus. Depending on the circumstances of the case, the location of harassment can be important in a student-on-student Title IX case, but location is only one factor in determining the control over context. Considering all of the circumstances of this case and viewing the facts in the light most favorable to Brown, we hold that Brown presented sufficient evidence to allow a reasonable fact finder to conclude the university had substantial control over the context in which Bradford assaulted Brown on September 12 and 13. This, I think, is an important point because the context of the harassment is dealing with the basis for the claim. It's not the context over the previous instances that they had notice of and failed to act about. So it's because they had authority over the context in which the event that is giving rise to the claim occurred. That's what is justifying the Title IX action. And so that's the factual weakness that the plaintiffs have in their particular complaint here. The context that is giving rise to the liability, the claim of liability that they're presenting, is the King Road house and the murder that took place on November 13, 2022. And there are no facts alleged that would support that WSU had any control over that context. So only if the context of WSU and what was happening there can somehow be stretched to permit a different harm to different people in a different context is that claim going to be justified under the Title IX standards. So there's undisputed evidence that the university had control over the off-campus housing. After he finished his freshman year, he moved into another off-campus house with other members of the football team. The university and football program allowed him and his teammates to live off campus only with the permission of their coaches. The head coach testified in his deposition that under Player Rule 15, permission to live off campus was conditioned on good behavior and could be revoked. The very existence of this off-campus player's residence was therefore subject to the coach's control. Even behavior as innocuous as being late to appointments or receiving bad grades could result in players being forced to move back on campus. The university's students' code of conduct applies to student conduct both on campus and off campus, because off campus misconduct can affect student health, safety, and security as much as on campus misconduct can. The code seeks to hold students and organizations accountable for misconduct and to prevent it from happening again in the future. The university issued a no contact order to Bradford on behalf of student A that expressly applied both to on-campus and off-campus spaces. As the dissenters recognize, an element of school sanction, sponsorship, or connection to a school function is required for a school to control an off-campus context. Here, the university's rules and sanction authority created such a connection. So what the plaintiffs are going to have to do here is to try to argue that because Bryan Kohberger was subject to codes and policies and contracts and so forth that required him to maintain good behavior, to be responsible and good ethical character and so forth, and that those obligations applied off campus as well as on campus, they're going to have to argue that that means that gives the university control over pretty much anywhere off campus, because there's no reason under this framework to distinguish the King Road house from anywhere else he could have gone and potentially harassed somebody. He could have gone to the grocery store and done it. He could have gone to the gas station and done it. He could have done it on the street. He could have done it in a church. And there's no particular relationship between the school and any of those locations that would give the university particular control over it. Their control is just over Kohberger. And so I am not sure that this case is going to stand for the proposition that simply by having a code of conduct that allows control over set standards for off-campus behavior, that means that somehow the university has control over the context of the entire off-campus world. I think it's going to be a stretch. So the discipline-related factor was important in these other cases. He was also subject to increased supervision because of the football rules, the football program. And so this is basically the bottom line. This is the bottom line. Viewing this evidence in the light most favorable, a reasonable fact finder could conclude that the university had substantial control over the context in which Bradford violently assaulted Brown on September 12 and 13. We're not going to go through this part about actual knowledge and deliberate indifference, although it is kind of interesting. Just it's not going to likely relate to anything at the pleading stage that we're at here, but it may present a factual question again should the case get to the jury. I could be wrong about that, but the deliberate indifference is likely going to be the issue here. That's a bit of a challenge for the plaintiffs because the case law makes it clear it's an extremely high standard, and the conduct at issue has to be so obviously problematic, and your response to it so clearly inadequate that it's like, who would do that? Nobody would do that. And I just think that's going to be a challenge under the facts that they seem to have alleged to work with in this case, that, even if some of this stuff is true, hard staring and, bad social interactions without something a little bit more explicitly threatening, it's just gonna, I think, be hard to establish that as the type of conduct that is so obviously dangerous and threatening and risky and so forth that there was a duty to respond differently to it. These are not crimes, as we talked about, very different from the cases that we've looked at so far, where the prior misconduct, the things that were putting them on notice that told the school you needed to do something differently here, were criminal acts. Very serious. We're dealing with allegations that are a bit more ambiguous, a bit more related to perception. And that is the main reason why I think it's ultimately going to be a fact issue, but case is going to have to get to trial in order to reach that point. Okay, so what we've gotten from the Brown case is that just because this took place off campus doesn't necessarily mean that Title IX doesn't apply. That if WSU has sufficient control over the context, then that's going to be enough. And so we've seen, even from some of the cases that like YikYak, okay, you got a duty to control what people are doing on YikYak. Pretty far afield from just your physical campus environment. So we haven't foreclosed the possibility that WSU could be liable just because of the fact that this took place on King Road. I think it's potentially, real problematic because the context of the harassment at issue is dealing with the murders. And there's no indication that WSU has control over King Road in that type of context. But we have that proximity to, the in the immediate vicinity of the school. Maybe that's gonna give them some leeway to get there. But this hasn't really addressed the question about what about the non-students? What about the non-students being able to make this type of claim? The whole basis of Title IX is the idea that you can't be deprived of educational opportunities, your enjoyment of the facilities and benefits of the school because of sexual harassment or discrimination. So if you're not even a member of the school, how do you get there? You haven't lost any ability to enjoy the benefits of WSU education because you never went to WSU. So there's some case law on that as well. We're going to go ahead and take a look at that. This one is out of the Third Circuit, and it is quite new. It's from May of 2025. I wasn't able to find anything out of the Ninth Circuit on this. Granted, I am not at all, a Title IX expert. So it may be there, but I wasn't able to find anything. This was like the most recent kind of prominent case that I came up with that dealt with a third-party claim under Title IX. And so this is going to give us, in our case, this is non-binding. The Third Circuit is not binding over district courts in Washington, but it will be persuasive. It will be persuasive authority that they can and presumably will rely on as they litigate the issues. So this case arises from allegations that during a cross-country flight following a fencing tournament, a state university's assistant fencing coach sexually harassed and assaulted the woman in the seat next to him. That woman was also a member of the fencing community. She was a coach at a private fencing school that she owned. She alleges that when she told the university's head fencing coach, say that 20 times fast, about this incident, the coach rebuffed her, pressured her not to report it, and then along with the assistant coach, initiated a retaliation campaign against her within the fencing community. Even more, she claims that when the university eventually investigated the matter in response to her formal complaint, it confirmed the truth of her assertions, but concluded that the assistant coach had not violated any university policy. Based on those two allegations, the private fencing coach sued the university, the two coaches, and the university's Title IX coordinator in the federal district court in the federal district where she resided, even though neither the university nor any of the sued employees resided in that state. She claimed that the defendants violated Title IX of the Education Amendments of 1972, and she also brought several state law tort claims. All of the defendants moved to dismiss the complaint for failure to state a claim for relief, and all but one of the defendants, the assistant fencing coach, also challenged venue in at least one respect. In response to those motions, the district court transferred the case to a new judicial district. So, dealt with that. After the transfer, the plaintiff amended her complaint and the defendants moved to dismiss the claims against them. The transferee district court dismissed the entire suit. As a matter of first impression, it held that to bring a Title IX claim, a plaintiff must be within the zone of interest protected by that statute, and that the plaintiff, as neither a student nor an employee of the university, was outside of that zone. As for the state law tort claims, the transferee district court applied the choice of law rules and dismissed them as untimely or implausible. On de novo review, most of those conclusions are correct. A Title IX claim must be within the zone of interest protected by that statute. But the student or employee formulation of the Title IX zone of interest tests is inaccurate, and under a correct understanding of the zone of interest protected by Title IX, the private fencing coach's Title IX claims against the university related to her exclusion from fencing events that were hosted or supervised by the university, as well as any aspects of the retaliation campaign that occurred or had harm therefrom manifested on campus, are within that zone. Also, many of the state law tort claims are untimely, blah, blah, blah. So we're not really concerned about the state law claims here. We are interested in the federal claim. And so what do they say? You got to be within the zone of interest of Title IX for your claim to stand. And so it's not enough to just say you're not a student here or you're not an employee here. Third party, non-students, non-teachers, etc., can potentially file Title IX claims, but the claim has to be within the zone of interest. And so in this case, we go back to having this relationship: exclusion from fencing events hosted by the university. Okay. So things that they did that kind of participated in and contributed to this harm that she experienced, as well as any aspects of the retaliation campaign that occurred or had harm therefrom manifested on campus. You're injured on campus, the harm is related to things on campus, it's within the zone. If not, it's not. So let's take a little bit of a closer look here. Don't need to get too into the factual background. Don't need to get too into the procedural background. You know, we're interested primarily in just the Title IX decision in this zone of interest. So remember, we were in the same context, deciding as a matter of law based on the pleadings. Are you even going to get there? So that's the context we're in with the plaintiff's case. Zone of interest is something that can be litigated based on the allegations. So the district court dismissed the claims on the ground that she was not within the zone of interest that the statute was designed to protect. Under this court's, these are the standards of review for dealing with the failure to state a claim, the motion to dismiss. So in this particular context, the court reasoned that a plaintiff must fall within the zone of interest protected by Title IX as a prerequisite to stating a claim for relief under Title IX's implied cause of action. In applying that zone of interest test at the motion to dismiss stage, the district court reasoned that only students, employees, or persons so closely tied to a university that they are essentially students of an educational institution receiving federal funding are within the zone of interest protected by Title IX. Although it did not disregard any of Oldham's allegations as speculative or too conclusory, the district court determined that Oldham did not plausibly allege that she was a student or an employee or that she had a similarly close relationship with Penn State. The district court therefore concluded that Oldham was outside of the zone of interest protected by Title IX, and it dismissed her Title IX claims with prejudice. That ruling presents a question of first impression for this court. That is to say, whether the zone of interest test applies to Title IX claims. For the reasons below, it does, and some of Oldham's claims are plausibly within that zone. Because we're in the standard, it's not can she prove it or not, it's just has she alleged enough that if you believe it and if she's able to substantiate it at trial, is it enough to establish she's within the zone of interest? Although similar considerations have deep roots in the common law, the Supreme Court originally developed the zone of interest test as a means of determining who could sue a federal agency under the Administrative Procedure Act. But the Supreme Court has since made clear that zone of interest considerations apply to all statutorily created causes of action unless expressly negated. So this is an area of law that is specific to being able to sue someone federally, having a federal cause of action that has been created by law. Accordingly, it is now presumed that a statutory cause of action extends only to plaintiffs whose interests fall within the zone of interest protected by the law invoked. In analyzing another federal civil rights statute, the Fair Housing Act, the Supreme Court did not reject the presumptive application of the zone of interest tests, as neither the text of the statute nor its later amendments suggested that Congress intended to deviate from the zone of interest limitation. The presumptive application of the zone of interest test is similarly not rebutted with respect to Title IX's implied cause of action. Nothing in that statute's original text or its later amendments suggests an intention to deviate from the common law rule. Thus, the zone of interest test applies to Title IX, and only those persons within the zone of interest it protects are eligible to sue under its implied cause of action. Determining whether a person is within the zone of interest protected by a statute requires analyzing the statute's text, construed using traditional tools of statutory interpretation. Applied to Title IX, much of its protective sweep comes from its prohibition of discriminatory actions taken on the basis of sex with respect to federally funded education programs or activities. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any federal education program or activity receiving federal financial assistance. As originally enacted, the term program or activity was undefined, but after the Supreme Court's decision in Grove City College versus Bell, interpreted that term narrowly to mean that receipt of federal funding did not impose institution-wide obligations. Congress enacted the Civil Rights Restoration Act of 1987, which defined program or activity to encompass all of the operations of a college, university, or other post-secondary institution. So not just school, but everything that a college does as part of its operation. Janitorial services, food and beverage service, housing, all of the things, sports, all of the things that aren't even necessarily related to the educational mission, but are part of the school's operations subject to Title IX. So thus, Title IX covers the operations of colleges and universities that may be reasonably considered, at least in part, educational. So not completely separate from, but at least some tenuous connection with the educational program. But that understanding alone does not sufficiently define the zone of interest protected by Title IX because, as legislation under Congress's spending power, Title IX is subject to a clear statement rule. Under that canon of construction, Congress must clearly state any conditions on the grant of federal funds so that funding recipients can knowingly decide whether to accept those funds. And based on the Supreme Court's holding that Title IX creates a private cause of action, one of the conditions attached to the receipt of Title IX funding is exposure to civil liability for violating Title IX's non-discrimination provisions. In its Title IX precedents, the Supreme Court has clarified the bounds of such liability in several respects. And from that guidance, two requirements emerge for being within the zone of interest protected by Title IX. First, for a Title IX plaintiff to be within that statute's zone of interest, the funding recipient must exercise substantial control over the individual who mistreats the plaintiff based on sex. So we have the school exercising control over Bryan Kohberger. We got that element to it. Second, the Title IX funding recipient must have substantial control over the context in which the mistreatment occurred or manifested. This is the standard we just went through. They got to have control over the perpetrator, and they have to have substantial control over the context of the harassment or abuse. Applied here, for Oldham's claims to be within the zone of interest protected by Title IX, Penn State must have had 1, substantial control over the alleged offenders, and 2, had substantial control over the context in which the complaint of discrimination either occurred or manifested. So in our situation, we are less interested in the control they have over Kohberger. Like I will grant, they've established a lot of control over Kohberger, a variety of policies, ability to discipline him, and so forth. The issue here is the conduct, the context of the harassment. So the second requirement for the Title IX zone of interest test is distinct from the first requirement. This case explains it is not enough that the offender was aided in carrying out the sexual harassment by his or her position of authority with the institution. And here, Oldham alleges that the discrimination occurred or manifested itself across multiple contexts. The setting in which Oldham's sexual harassment claims occurred and manifested was a flight from Portland to Chicago. As a baseline, a recipient's grounds or campus generally qualify as a context over which it exercises substantial control. So your own campus, yeah, that's a given. However, there may be instances in which a funding recipient exercises substantial control over an off-campus setting as well. And it is not difficult to imagine a scenario in which an off-campus flight might be subject to a university's substantial control. A chartered flight, or one on which the students are traveling with a university chaperone may well qualify. But the amended complaint lacks allegations about Penn State's substantial control over the flight, even though its allegations support Penn State's substantial control over Abashidze. I don't know how to pronounce that either, the perpetrator. And without allegations connecting the flight itself to the operation of a program or activity of the university, Oldham has not provided a basis for inferring that Penn State had substantial control over that setting. This seems to be fatal to the claim because there is no allegation that WSU had any control over the King Road House. They've focused extensively on the university's control over the WSU campus. But the activities on the WSU campus are not the harm that are giving rise to liability. The victims of those activities are not the plaintiffs in this case. And so this is kind of reiterating what we got from Brown, which is that the context of the harassment is not just this overall pattern of activity that took place. It's the harassment that you're suing for. And so if you're arguing the murder is what gives rise to liability, because that's your plaintiffs, that's the harm that you're relying on, that is what has to be within the zone of interest. And that is the context over which the university has to have substantial control. And so I'm not seeing any meaningful factual distinction between school employees off campus on a flight behaving towards a third party and school employee TA off campus in a private home acting towards a non-student, non-employee third parties. Not seeing any real obvious factual way around this limitation. It does not seem that the claim is going to satisfy the zone of interest test. Now, ones that do fit within the zone of interest are based on these claims about the retaliation campaign. So what happened on the flight, you can't sue for that. But these other things that are related to campus control, she can potentially recover for. So these fencing events at a safe sport hearing, places where it manifested in her actual or constructive exclusion from fencing tournaments and networking events, loss of employment opportunities as a fencing coach at Northwestern University and the University of North Carolina, and the departure of students from her own fencing school. Some of these contexts may be inferred to be within Penn State's substantial control for purposes of Title IX. So how? Okay, how these things, the loss of, in our context, we're worried about, loss of life, loss of able to continue with your education at University of Idaho and so forth. How can these fall within the zone of interest in Title IX? It is a reasonable inference that conversations that were part of the retaliation campaign occurred on Penn State's campus. The amended complaint alleges that the campaign was widespread, so it is reasonable to infer that at least some conversations occurred in their offices, at Penn State fencing events, or otherwise while Abashidze and Glon were on campus. Any conversations that occurred in those settings were within Penn State's substantial control and thus within Title IX's zone of interest. So to the extent they carried out, maybe we can extend this to conducting, planning, and preparation of, and so forth of their violative activity, that is potentially within the zone of interest. But for the other aspects of the retaliation campaign, those that occurred off campus or at locations in which Penn State was not hosting or supervising events, the amended complaint does not provide a basis for inferring that Penn State exercised substantial control over those settings. Even so, the second requirement for the Title IX zone of interest test requires substantial control over the context in which the discrimination either occurred or manifested. And even without Penn State's substantial control over off-campus settings in which the retaliation campaign may have occurred, the retaliation campaign is alleged to have manifested in settings over which Penn State had substantial control. In particular, she alleges that because of the retaliation campaign, she was excluded from events hosted by Penn State, including an invitational fencing tournament, the NCAA fencing championships. From the allegation that Penn State hosted those events, it may be reasonably inferred that Penn State had substantial control over those settings, such that Oldham's retaliation claim for exclusion from those events satisfies the second Title IX zone of interest requirement. So this is much more direct. She was trying to have some type of relationship with Penn State and wasn't able to. We don't have any kind of allegation that this particular limitation would apply, that the Idaho 4 students were trying to have any type of relationship with WSU, that because of being murdered, they weren't able to pursue that. The other settings were not within the substantial control. Other fencing tournaments in other locations, other events and things like that. No indication that Penn State was in control of that. So hiring decisions and so forth of other schools, can't say that Penn State had control over Northwestern's decision, not to hire you or not. So this gives us the very limited framework in which this complaint is going to have to navigate to get to trial. This may be enough, in my opinion, to get them past the pleading stage, because the conversations that occurred on campus, okay, the things that they did on campus to facilitate and carry out this discriminatory conduct, that can be enough to bring it within the zone of interest. And so the equivalent situation in the civil case that we're looking at is the activity that they have alleged Kohberger engaged in on campus that was specifically targeted towards this harm. Any planning, preparation, and so forth. So I think this is enough to get them past, potentially anyway, past the pleadings stage, because they have alleged he stalked them, and that he likely did that on campus using, school provided internet facilities and things like that. They've alleged it. So I think that's going to be enough for them to meet this zone of interest test to get them past the pleading stage to overcome a motion to dismiss. But when it comes to summary judgment and coming up with the evidence to be able to prove that, that's where the real question is going to be. We'll find out, I guess, if Bill Thompson was, reasonable in his statements and his interpretation of the evidence that was developed in the criminal investigation, where they certainly would have had an incentive to try to show that Bryan Kohberger was engaging in activity that was stalking type activity. But according to him, it's false. They were never able to substantiate that. The allegations in the complaint that are a little bit more general, I don't think are going to get him there. Things like he's researching, weird serial killers and, has these strange interests and things like that. Not sure that's going to satisfy the standard of the zone of interest test, because it's not a part of the manifestation of his actions towards the Idaho 4. So they might have, a limited pathway, in my view, to get there, to get to discovery, just based on the allegation that he stalked them. But they're still going to have an evidentiary burden that they will have to clear to get this case to a trial once it gets to summary judgment. So that is my legal deep dive into the complaint, and why. At the end of the day, my conclusion on this, it's very much legally on the back foot. This is not a strong claim. The negligence claim, I don't think, is going to survive a motion to dismiss brought at the preliminary stage. The Title IX claim has a slightly better chance of proceeding based on this interpretation of the zone of interest and the context of the harassment to include on-campus activity that is manifesting the harm you're complaining of. And so the stalking leading to the murder conceivably could fit within that particular framework. So the Title IX complaint, I think, could survive. But when it gets to summary judgment, they're going to have the evidence to back it up. And it's not clear, just from what is in the public sphere at this point in time, the information that's out there and what we've been told, and the details about the investigation that can be verified and so forth, that standard is going to be met, that they can prove on-campus activity by Bryan Kohberger that was planning, preparatory, and so forth. So we'll see. But ultimately, can't say I have a lot of high expectations for this case being allowed to move forward. So thank you for joining me, guys. This was a little bit long and intense, but just always presents some interesting context to see what the law itself says and how does that relate to my knee-jerk reaction of like, but they're not even students there, and how do they have standing to, challenge harassment of other people at WSU and things like that. So this is kind of the hallmark of what the legal practice is instead of just assuming I know what the answer is going to be, we got to go look at the law and see what the cases have said. The law is out there to be looked at and examined. It is not something that attorneys just make up in their heads. So that is a little look at the legal process that I wanted to share with you as it applies to the civil complaint based on Bryan Kohberger's activities at 1122 King Road. So thank you all for joining me. Hope that you found that interesting. I am going to be keeping my eyes out for a motion to dismiss, which I expect will be forthcoming. Like I said, they have just removed the case up to federal court. So there's going to be some delay before anything is done, but a motion to dismiss is typically one of the first actions that the defendant will take in a civil case when there's a basis to make the argument, as there certainly seems to be here. Normally, the deadline is within 30 days of being served with the complaint, but that is often and routinely extended, particularly when the response is going to be a motion to dismiss rather than an answer. So probably within the next couple months, we'll be seeing something along those lines. I will be taking a look to see how well this lines up with my analysis and my predictions and so forth based on this analysis we've done today. So do stay tuned. I will keep an eye out and share my thoughts when I have them. Appreciate you all joining me. I will see you next time.